impressive.
Very good.
Thank you.
Yes. I'm going to ask for 6 minutes. Yes. Yes, sir. I'm Davis Whitfield Cargo. Robert McFarland. Roderick, nice to meet you, sir, and thank you.
Nice to meet you.
The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon. My name is Lucy Inman, and presiding with me today on my right are Judge John Arrowood, and on my left, Judge Toby Hampson. We have two matters left on the calendar this afternoon. The next matter is Court of Appeals docket number 20-226, Rachel Lynn Osborne versus Heath Paris, Jordan Ashworth, and Government Employees Insurance Company. Counsel, are you ready to proceed? Very well. Very well. You may take your, I think you're more than 6 feet away from each other. It's your choice. If you feel more comfortable keeping your mask on, that's fine. When you're talking, if you feel more comfortable keeping your mask on, that's fine too. And how long for rebuttal would you like?
With the court's permission, 6 minutes.
6 minutes. Okay. Very good. Very good. Okay. Ready to proceed?
May it please the court. I'm Davis Whitfield Cargile. I'm a member of the Transylvania County Bar, and it's my privilege to appear today before you on behalf of the appellant, the plaintiff below, Rachel Lynn Osborne. With court's permission, I'd like to reserve 6 minutes for rebuttal. The Financial Responsibility Act is clear in requiring each policy of motor vehicle insurance that is written above $30,000, the minimum limits in the state, in requiring such policy to provide, in addition to liability coverage and uninsured coverage, it shall provide underinsured coverage. In addition, the statute is clear in requiring that the underinsured coverage and the uninsured coverage limits on such policy be equal to one another. We are here before this court because the trial court erred in failing to require GEICO to provide underinsured insurance coverage in addition to uninsured coverage in this case. The trial court also erred in allowing GEICO to reduce its uninsured coverage limits by the amount of the liability tender of another tortfeasor, and the court erred below in granting summary judgment on bad faith and unfair trade practices claims, which involve questions of fact. I plan to primarily address the coverage questions, but I'm prepared to address the bad faith and unfair trade practices claims if we have time, or if the court has, or if the panel has questions. Before I dive into the coverage questions, I would like to first provide us a brief statement of the case consistent with Rule 30. Ms. Osborne was a passenger on the back of a motorcycle on April 4th, 2017. The motorcycle was uninsured. She didn't know that at the time, but it was uninsured. The motorcycle was traveling on Crab Creek Road in Transylvania County, came upon a car that had its right blinker on. The car looked like it was slowing down and turning right. The motorcycle went to pass the car on the left. Despite its right blinker, the car turned left into the motorcycle, colliding with a motorcycle. Ms. Osborne was thrown a great distance from the bike. She suffered very catastrophic injuries and required multiple surgeries, and she will require multiple surgeries in the future. This is a case where we believe there's not enough coverage for Ms. Osborne's injuries. And because there's multiple vehicles involved, I've prepared, and I've shared this with my friend, a handwritten kind of summary of the policies that I will go over, because I think seeing what the policies are lays the framework to guide this court's consideration today. Let's see if my handwriting is dark enough. Bear with me.
There you go. That's better. Oh, wow. That's great.
my
Was-
handwritten notes. Am I going too bright?
You're going the other way.
I'm
Yeah,
going
need
the
to make
wrong
it,
way.
yeah, go the other direction.
Your Honors. Okay, we can see that. The motorcycle, as I said, was uninsured. The Ashworth car had $30,000 on a liability policy issued by Geico. Miss Osborne was also insured under her own policies. She had one in her name that was provided $30,000 of liability and $30,000 of uninsured coverage. She lived with her parents, and Geico acknowledges that she was an insured on her parents' two policies. One was a motorcycle policy that has $30,000 of uninsured coverage, and one was her parents' cars, which has $100,000 in liability coverage, $100,000 of uninsured coverage, and $100,000 of uninsured coverage. Geico has paid the $30,000 liability limits on Mr. Ashworth's vehicle. That was tendered on March 6, 2020. A month later, on April 6th, Geico paid $15,000 of Rachel's $30,000 UM coverage, $15,000 of her parents' motorcycles UM coverage, and $100,000 of her parents' $100,000 UM policy. We contend that she's entitled to $70,000 of underinsured coverage on her parents' $100,000 policy, and the remaining $15,000 on the two $30,000. The remaining $15,000 on each of the two $30,000 policies. I want to start with the underinsured coverage question, and that begins with the language of the statute. Geico acknowledges, my friend acknowledges, that the terms of the statute are written into the policy as a matter of law. And 20-279.21 is the Financial Responsibility Act. I'm just going to refer to the subparagraphs without citing to 20-279.21 each time if the court will indulge me. Subparagraph 2 spells out the requirement for liability coverage. Subparagraph B3 spells out the requirement for uninsured coverage. And subparagraph B4 spells out the liability for underinsured coverage. It begins by saying, and if we flip back to the very beginning of B, such owner's policy of liability insurance shall, in addition to the coverage in paragraphs, subdivisions 2 and 3, that's liability and uninsured coverage, shall, in addition to liability and uninsured coverage, provide underinsured motorist coverage to be used only on a policy written above the minimum limits in subsection 2. And then it also says later, and I've highlighted this, the limits shall be equal to the limits of uninsured motorist bodily injury coverage. So the statute begins by saying that the policy shall, in addition to UM and liability coverage, shall offer UIM coverage, shall provide, UIM coverage, and it shall be in addition to the UM coverage, and they shall be in equal amounts. There's no question that there are two tortfeasors in this case. One tortfeasor was uninsured, one tortfeasor was underinsured. The trial court below relied on Geico's, the case of Monty that was decided by this court that involved only a single tortfeasor. That case held that technically a vehicle that was insured under the laws of another state, which had less compulsory insurance than North Carolina, met the definition of both uninsured and underinsured under the Financial Responsibility Act. But with a single tortfeasor, they could only get one of the coverages, not both. This is not that type of case. This is not a single tortfeasor case. This is a multiple tortfeasor case. In Lunsford versus Mills, this court and our Supreme Court decided what it takes for UIM coverage, underinsured coverage, to be triggered. And all it requires to trigger the the obligation to provide underinsured coverage is for the underinsured vehicle, that's Ashworth's vehicle, the car, to tender its liability limits. And in this case, on March 6, 2020, Geico did that on behalf of defendant Ashworth, and that triggered the obligation to provide underinsured coverage.
But if they do the limits for the underinsured motorist, I'm looking at your math, you seem to be that your math says they don't get any credit for that against any of the other obligations, as I was reading your chart.
The uninsured coverage does not get any credit for the other coverage. The underinsured coverage does get a set-off for the $30,000 liability tender of Ashworth's liability carrier. My chart, I may have pushed it over too far, but we contend that Ms. Ashworth, and this comes straight out of the statute, that Ms. Osborne is entitled to $70,000 of UIM underinsured coverage. And that takes the $100,000 UIM limits on her policy and reduces it by the $30,000 liability coverage limits on Ashworth's vehicle that were tendered. And that's what the statutory analysis requires Geico to do.
So if we look at, it's record page 58, I think is what you're attributing those, the $100,000 UM and $100,000 UIM, correct? Now I lost your chart again. I guess it's a screensaver. There we go. Let me get to page 58. Thank you. What you're saying is that that policy, and you're construing the language in the statute that says you have to have an equal amount of UM and UIM, right? You're saying that under that policy, there's really $200,000 in coverage, not $100,000. Is that right?
I am saying that under this policy, there's $100,000 of uninsured coverage, and there's $100,000 of underinsured coverage.
I understand, which
And
adds up to two.
That does add up to 200.
Okay. And you're saying that you are giving credit, as it were, for the tender from Geico of Mr. Ashworth's limits because you're seeking another $70,000. And what is the total amount that you're contending that your client is entitled to?
Under coverage, she is entitled to, she's entitled to an additional she's entitled to $70,000 of underinsured coverage, and she's entitled to an additional $30,000 of uninsured coverage.
So that's $100,000.
Of additional coverage
additional
that Geico has not
coverage.
paid. Yes, Your
Okay,
Honor.
of additional coverage.
So it's your contention that there is a grand total of $260,000 of coverage between all the policies. $30,000, $30,000, 100, and 100.
That's correct, of the first party policies.
Yeah, okay.
And I want to, while we're looking at at the policy itself, I want to compare the policy to the statute. There's the coverage page on page 58 shows that there's combined limits of uninsured and underinsured limits of $100,000. There's no provision in 20-279.21 that allows the limits to be combined into one layer of coverage. The statute is very clear that underinsured shall be offered in addition to uninsured, and they shall be in equal amounts. And the policy reflects that underinsured is in addition to underinsured. In the record at page 70, it begins by stating, "We will pay compensatory damages which an insured is legally entitled to recover from the owner or operator of an uninsured motor vehicle." And then it goes on to say, "We will also pay compensatory damages which an insured is legally entitled to recover from the owner or operator of an underinsured motor vehicle."
So
There's
you're saying
not-
your argument is this is a unique case because you have two tortfeasors, one of whom is uninsured and another one of whom is underinsured.
Yes, Your Honor. In that respect, it's unique to the Monty case. In terms of statutory interpretation, it's not a unique case because the plain language of the statute makes clear, and the legislature chose specific words. And this court and our Supreme Court in the Lunsford cases, among others, has made clear that when this court interprets the statute and gives effect to the legislative intent, it gives effect to the words chosen by the
But
legislature.
we're bound by what Monty says if you only had a single tortfeasor, aren't we?
If we had a single tortfeasor case, you're bound by what Monty says. We don't have a single tortfeasor.
Okay, and
This
if,
is unique for Monty, and Monty does not answer the question presented by this court, which is the coverage in addition to, is the UIM in addition to uninsured coverage? And Judge Inman, I cut you off, and I'm sorry.
no, you go ahead, that's okay. I'll remember my question. Keep going.
Okay.
Unless you're at a stopping point, and then I'll ask you.
I'm happy to field your question, Your Honor.
Just to make sure, if by chance both Mr. Paris, the motorcycle, and Mr. Ashworth, the car, were uninsured, would the amount of coverage be $100,000 instead of $200,000?
That's a question that I don't think is clear, because...
And I realize that's dicta, that's not what's before us, but I'm trying to define the parameters of your analysis of the policy language.
Well, there is language in 279.21 B4, in subsection B4, that says that an underinsured vehicle meets the definition of an uninsured vehicle. And the court's holding in Monty involved a single tortfeasor, and I think this court got that decision right, that with a single tortfeasor, you got to choose one or the other. If there's multiple tortfeasors that might meet both definitions, I'm not sure how this court would resolve that question, but that's not the case before us. Before us, we have an uninsured tortfeasor and an underinsured tortfeasor.
Are you contending that the policy language conflicts with the Financial Responsibility Act?
I'm contending that GEICO's interpretation of its policy conflicts with the Financial Responsibility Act. I don't see anything in the policy itself that says that a insured cannot collect both uninsured coverage and underinsured coverage when there's two tortfeasors. In fact, the language that I read to you from the policy a moment ago makes clear that in addition to the uninsured obligations, the policy will pay underinsured obligations. So I don't think there is any language in the policy that limits the plaintiff to only uninsured coverage or underinsured coverage. But if my friend contends that there is policy language, or if this court determines that there is policy language that conflicts with the Financial Responsibility Act, the result is clear. The policy has to give way to the statute.
But you're not identifying any language in these policies, and it's not your contention that there's any language in these policies that violates the Act. You're simply arguing that GEICO's interpretation of the policies conflicts with the Act.
The language in the policy that would conflict with the Act that I read it is the combined limits language, to the extent that it's interpreted to mean that underinsured coverage is not provided in addition to uninsured coverage. Because the Act is clear. You have to provide underinsured coverage in addition to uninsured coverage for policies written above the $30,000 compulsory limits. And if there's doubt, this court and our Supreme Court have been clear that the ambiguity in the policy is resolved in favor of the insured. Ambiguities in the statute are resolved in favor of the insured. And that's because the avowed purpose of the Financial Responsibility Act is to compensate the innocent victims of financially irresponsible motorists. And it's a remedial statute. It's to be construed liberally so that the beneficial purpose intended by its enactment can be accomplished. In the Lunsford case that our Supreme Court handed down this summer, and I think the same principle is in the Lunsford case, Lunsford versus Mills, the earlier case, interpreting ambiguous language in the statute in favor of coverage is in keeping with the purpose of the Financial Responsibility Act because it allows the injured North Carolina insured to access the UIM coverage they paid for in a greater amount of circumstances, reducing the likelihood that the loss or damage of the uninsured motorist will be borne by the victim alone. And so if this court finds that language that I think is very clear, shall, in addition to, provide UIM coverage in equal amounts, if it's ambiguous, it has to be resolved in favor of coverage. I don't think it's ambiguous. I think it's clear, and I think it was the obligation of the trial court, and it's the obligation of this court to give effect to that language. In terms of, I want to address the the uninsured credit issue, the $30,000 of uninsured coverage that GEICO reduced its coverage by. There is no provision in the Financial Responsibility Act that authorizes the carrier to reduce uninsured coverage by another tortfeasor's liability coverage or liability payment that has already been made. And that's what GEICO has done here. In multiple cases, MABE is one of the ones that comes to mind, but there's another one that I'm not bringing the name to my mouth right now. The court has held that if there's an exclusion or policy language in the statute, in the policy, that is inconsistent with the statute, it has to give way, and it's not authorized. So if the General Assembly did not intend for UM, uninsured coverage, to get a credit or a set-off for the liability coverage of another tortfeasor, then a policy language that gives it that credit or that set-off or that reduction in coverage is unenforceable. In the MABE case, we were dealing with a family exclusion policy that was not intended, and the court struck that down because it wasn't intended in the Financial Responsibility Act.
Okay, and so, and the language in the Financial Responsibility Act that you contend is violated by this credit is what?
The language in subsection B3 that entitles and says that the insured shall be entitled to combine the greatest limits on each policy on which she is an insured. That's the stacking language that this court and the Supreme Court has upheld multiple times that says that she is entitled to combine the $30,000 on her policy with the $30,000 on her parents' motorcycle policy and the $100,000 of uninsured coverage on her parents' car policy to reach $160,000. Authorizing the UM carrier to reduce its coverage by another tortfeasor when it is in clear conflict with that language. Under the maxim of expressio unis exclusio alterius, which I probably butchered, pardon my South Carolina Latin, the General Assembly did give UIM, underinsured coverage, the set-off or the credit for the liability tender of the underinsured motor vehicle. By trying to reduce its UIM coverage by the amount of that, GEICO is really trying to double dip on the credit that it's only entitled to on UIM coverage. And so we respectfully submit that the trial court's error or order granting summary judgment on the UIM question should be reversed.
So the General Assembly knows how to allow for that credit, allowed for that credit in UIM. They didn't have that language for UM.
That is exactly correct, Your Honor.
Okay.
I have about a minute left. I do want to briefly touch on the unfair and deceptive trade practice and bad faith claims. Those involve questions of fact. On page 16 to 18 of the reply brief, we set forth, I think, 9 different times that Geico's kind of evolved, coverage positions evolved and changed, none of which were supported by the statute. I'm sorry. The Miller case that we cite, Miller versus Nationwide and Murphy versus Nationwide, make clear that the allegations in the complaint state a claim for bad faith and unfair trade practices. We've included citations to the record for those 8 or 9 instances where Geico took evolving coverage positions that were not supported by the policy, that were not supported by the statute. I note the one that's the most obvious, glaring, and that it has not stood by before the trial court or before this court was the position that there's no coverage if there's a solvent joint tortfeasor. I see that I'm into my rebuttal time, so I will reserve the rest of my time with the court's permission.
Good afternoon.
Good afternoon. May it please the court, my name is Ann Rao. I am from the Forsyth County Bar, and it is my honor to appear before you today representing Geico in this matter. I would like to begin by addressing, first of all, the chart that you saw that my friend placed on the viewer for you to see, because I believe that the main point in this case is evidenced by that chart. That being that Ms. Osborne's contention throughout the case has been that she is entitled to both $100,000 in uninsured coverage and $100,000 in underinsured coverage. That is her allegation, as I understand it, under what I've referred to in our brief as Policy 65. Someday maybe somebody will shorten those policy numbers, but until they do, I used those last 2 digits for convenience. Policy 65 was the policy provided to Ms. Osborne's parents. That policy provided one combined limit for UM uninsured and UIM underinsured coverage. As noted on the declarations page for the policy, the coverage that was purchased by Ms. Osborne's parents was a combined limit of UM and UIM coverage. In the Financial Responsibility Act, Section N, as my friend noted earlier, it's a 20-279.21, but Section N of that statute clearly says that the statute cannot be construed to provide greater amounts of UM or UIM coverage than what was purchased.
Well, doesn't the declaration page show that they paid a sum for UIM and another sum for uninsured?
On the combined policy, Your Honor, they paid a single premium for the combined limit.
Are we looking at, I mean, let's get to
Record page, can you?
Policy 65 is going to be pages 58 and 59 of the record, I think, but would appreciate counsel confirming that, Ms.
Yes,
Brown.
ma'am.
Okay.
Yes, ma'am. So on,
Okay.
on the record, in the record on appeal on page 58, that is the declarations page for policy 65. The policy number's in that top right-hand corner.
Okay.
And if you look, Judge Arrowwood, you asked specifically about the premium that was paid. So about 3/4 of the way down the page, you'll see where it says coverages, and then it lists A, C, and D. A is the liability coverage. C is the combined uninsured, underinsured bodily injury liability for each person and each occurrence. The limits purchased by Ms. Osborne's parents, and you see their name on the top of this policy, was $100,000, $300,000. So $100,000 per person, $300,000 per accident. That's in the situation where there's more than one injured party claiming benefits.
So hypothetically, and I'm just trying to understand the parameters of your argument.
Yes, ma'am.
Your argument is that this is that her parents paid one amount of money for combined UM and UIM coverage of $100,000.
Yes, ma'am.
Hypothetically, unfortunately for Ms. Osborne, her injuries and her damages far exceed the amounts of money that we're talking about. Hypothetically, if Ms. Osborne had suffered damages of $90,000, then whether it's one vehicle or two vehicles, there wouldn't be a problem here. Your argument is that if you exceed $100,000, you've exceeded the limits of this policy. Is that right?
Yes, ma'am. That is correct.
Okay.
The
It's just
limit,
not a $200,000 policy as I understood Mr. Cargill to say, and I said 200,000, and he said, well, it adds up to 200,000, but you have to look at this and this. And you're saying, no, 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 no. It's $100,000. There's not another $100,000.
yes, ma'am, that is exactly what we're saying. That the limit of liability, which is very clear here, the limit of liability is $100,000. If I could just quickly finish responding to Judge Arrowood. Judge Arrowood, you will see that on that, if you follow reading left to right under that coverage C, there is just one premium amount paid for that coverage. So there is one coverage with a single limit with one premium amount paid. And yes, ma'am, Judge Inman, in further response to your question, unfortunately, in the world of doing automobile defense work, we unfortunately do see that in many different kinds of cases where a person's damages may exceed the coverage available. And that's in cases, that happens in cases where there is not even a question of coverage. Perhaps all of the parties agree on the amounts of coverage available, may even agree on the damages and the extent of the damages, and there's simply not enough coverage to fully compensate the victim. So we do see that. And in this case, perhaps if there had been less extensive alleged damages, I don't know, would we be here arguing the same point? Maybe it would not have come up. Maybe it would have. We don't know because this is at the stage we're at on the declaratory judgment question. We don't know what Ms. Osborne's allegations would have been about the extent of her damages. But the point is, in any event, whatever her damages are, the limit of liability is $100,000. And with all respect to Mr. Whitfield Cargill's argument earlier, Ms. Osborne has not cited to you in her brief or in the argument before this court, has not cited one case from this jurisdiction or any other to support the proposition that she can recover $200,000 under that policy. To the contrary, we have cited case law from this court in support of GEICO's position that the combined limit is the limit of liability and that Ms. Osborne can recover one or the other, but not both. That is the Monty case, and I recognize and acknowledge that there are factual differences in that it involved a single tortfeasor. However, this court, in ruling on that case, did not focus on that distinction in any way. This court
Well, but
said,
it wasn't before the court then, because there was only a single tortfeasor, and so the question was, what does that provision provide for a single tortfeasor?
but the ultimate question, Your Honor, I believe was the same. The ultimate question was, can this injured party recover one or the other or both, UM or UIM?
But in Monty, because you only had one tortfeasor, it makes sense to say, you know, it can't be both, it's one or the other. But here, we literally have one uninsured and one underinsured.
Another, Your Honor, if I may, I apologize. Did I interrupt
No,
you?
go ahead. No.
And one thing that I do think is also important in looking at the Monty case, one of the things that this court did was this court said, we haven't had this issue before us before. We haven't found any other North Carolina law on it, and they did look outside of North Carolina. And we've discussed that case in our brief as well, which is a case from, from New Jersey. And this court looked at that case, so it's not as if we just pulled it out of the air. This court did examine that case, and one of the things the New Jersey court talked about was that in making this holding that it has to be either or but not both, that is consistent with the purpose of the Financial Responsibility Act.
Now, was the New Jersey case a single tortfeasor or a multiple tortfeasor?
I believe, Your Honor, that it was a single tortfeasor as well. However, again, what I would suggest to the court is very significant is that the New Jersey court, and then this court in relying upon that case, said that it is significant that this holding of you cannot recover both is consistent with the purpose of the Financial Responsibility Act, which I believe we all agree the purpose of the Financial Responsibility Act is to compensate innocent victims who may have suffered an injury at the hands of a financially irresponsible motorist.
Okay, what about if we had, and this is a hypothetical
Yes, sir.
that's not covered here, but what if we had, let's say, the plaintiff was riding the motorcycle, and the motorcycle wrecked, and she was gravely injured, and before the ambulance came, somebody else came down and ran over her, and they were underinsured.
Sure.
Would there be, is it your contention there'd only be the $100,000 coverage there?
So, and I assume we're assuming
She's
that
she's still in the road,
Yeah.
but it's a totally different incident. It's not a combined incident.
Okay. I believe the difference there, Your Honor, is that there are two different occurrences. In this case, we have a single occurrence, and the cases do talk about a single occurrence. In this case, we have one motor vehicle accident. In the case you're talking about, I'm sure there would be some argument about what a single occurrence might be. My argument in that case would be that there were two separate motor vehicle accidents that could lead to a different result. But what's important in this case is while we do have two different vehicles, we have a single occurrence.
Well, here, you know, you have $300,000 limit per occurrence, right? In the policy language, 100,000 over 300,000.
Yes, ma'am. So that is 100,000 per person, 300,000 per accident. So, for example, if there were 3 injured parties, all claiming benefits, you might reach that 300,000.
Or
Each
if there-
one of them could have 100. If there were 6, then not each one would be able to get 100 because it would be capped at the limit of 300. So that 300,000 does not come into play. I think we need to be careful we don't get that confused in our case. The 300 is not applicable to our case because there is one injured party seeking benefits. So it is when it's all written out, it is a 100,000 per person limit. The 300,000 applies per accident, but only in instances where there is more than one person seeking benefits. And in this case, only Ms. Osborne is seeking benefits. So that is the distinction there.
And the per person language there, each person, meaning each person who is a covered insured, each person who is receiving benefit, not, for example, each person who was a tortfeasor, because if it was that,
Yes, ma'am.
it would be, would
That
you
is-
agree, then it would
yes,
be
ma'am.
$200,000. It's each person who is injured.
It is each person who is injured or claiming to be injured and seeking benefits. Similar to if you look up at coverage A, sometimes it's a little bit easier, at least to me, to understand in the liability context. It would be similar. You have the same 100, 300, and that's if I ran into my friend's car and they are seeking benefits from me. Again, it's one person claiming benefits in the amount of that 100,000. So it is, yes, that 100,000 applies to the person seeking the benefits, not to anything else. And, yes, ma'am.
Do you agree with Mr. Whitfield Cargile that any ambiguity has to be construed in favor of coverage?
I do agree that the law of our state is that ambiguities would be construed against the drafter of the policy. Yes, ma'am. I do not agree that there is any ambiguity in this policy. I believe that the policy language, it's our position that the policy language is very clear. I think that also applies, if I could touch briefly on the issue as well of the credit, which has been discussed. I believe that that is very clear policy language that is not in conflict with any statute. The argument here with regard to the credit issue, as you've heard it already discussed, has been a significant point of disagreement throughout the case, and it revolves around the limit of liability provision that is contained in each policy. Every one of the three policies has a limit of liability provision. In our brief, we quoted one of those limits of liability provisions. We noted that the other two have a slight wording difference, but not in any way that materially changes anything in regards to what it means. That limit of liability provision says, this limit of liability, and I'm just quoting parts of it, not the whole thing, shall be reduced by all sums paid because of bodily injury by or on behalf of persons who may be legally responsible. That is very clear language. There is no ambiguity to that.
And I'm trying to find it in the record in
Yes, ma'am.
policy 65, and it is different, because what you were reading, I see on page 43, which is not policy 65.
Yes, ma'am. It is, I'm sorry, did I interrupt you?
No.
Okay. It is in policy 65. It should be on, I believe, it is on page
72.
It's 86, I believe. Let me double check that.
If you look back on page 72, Judge Hampson has
72? Let me see what.
about two-thirds of the way down the page is the limit of liability provision, and then under number 4 is the limits of bodily injury liability shown in declarations for each person in each accident shall be reduced by all sums
So
paid.
And that's for the combined uninsured.
page 72 is referencing under the combined, let me see that.
It appears to be under policy 65.
It does, yes, sir, it is under policy 65
Thank you.
as well. Yes, sir. There is also some similar language in the endorsement that may be slightly different. The slight difference in language is it does say the limits of bodily injury liability shown shall be reduced by all sums. It's just a slight difference in language, but referencing the same thing, just with a, and we put that in bold in the brief just so you could see the words that are different, just to be completely transparent, but we do not believe that has any change in the meaning. Essentially, the limits of liability provisions contained in each policy are the same. They say the same thing. They say that the limit for whichever it applies to, for example, in policy 65, it would be referencing specifically the section for combined UM and UIM coverage. And it says that the coverage provided in that section shall be reduced by all sums paid by or on behalf of a person who is legally or who may be legally responsible.
And did you reduce that in your payment?
Yes, sir.
65. And did you
Well-
also reduce that in the, have you double dipped, I guess?
No,
is my
sir.
question.
And
Why haven't you?
I misspoke. Let me say that again. I misspoke because I answered your question before you finished. What I tell all my clients not to do, I just did. So I apologize for that. What Geico did out of a convenience, it was really done for convenience. Geico determined that the appropriate amount of the credit would be $30,000. That was the amount paid under Mr. Ashworth's liability policy. I believe we're in agreement that the amount at issue here is $30,000. Geico applied that credit in a pro rata basis. That's based on some other provisions in the insurance policy that I don't think we need to get into as much today, but it's the other insurance clause in the policies that allows for the credit to be applied pro rata. They applied the credit in the amounts of $15,000 each to the policy, Ms. Osborne's own policy, and to the motorcycle policy of the parents. That's why on the chart that you saw earlier, it said $15,000 was paid under each of those policies. Certainly, that pro rata credit could have been extended to policy 65, but out of convenience sake, it was just the checks were written for $15,000 and $15,000 and $100,000.
So if you've got, just, and pardon my shorthand, and pardon me for interrupting you.
No, ma'am, yes.
I'll refer those to those two as smaller policies.
Sure,
Okay?
sure.
So the $30,000 that's paid under Mr. Ashworth's policy, Geico says to itself, we get a credit for that. You know, we get a credit for that. Because it was paid out of the smaller policies, and again, I understand the language, you know, to counsel who study policy language all day, every day, these nuanced differences between the policies, you may have some appreciation for, oh, it doesn't really matter.
Yes, ma'am.
At least for this judge, I don't take for granted any difference not having significance. So really, the limit of liability that we should be looking at for this question would be on those smaller policies and not on policy 65, because you're saying Geico didn't take any credit off of what it paid to Ms. Osborne under policy 65.
I think that that is certainly one way of looking at it, yes, ma'am, and I think that's a fair way to look at it. I think, however, Geico could have taken the credit against all three policies.
You would think that it could take a credit adding up to more than $30,000?
No, ma'am. No, and I'm sorry if that's what I
Okay.
insinuated.
Okay.
No, ma'am, not at all. Our position is that the credit is in the amount of $30,000. That is all.
So it could have taken 10, 10, and 10.
Yes, ma'am.
Okay.
Yes. That's, and I apologize if I
No, no,
inferred otherwise, certainly did not mean that. In this case, just to go over the math, When Geico made its determination after seeking a coverage opinion, it was determined that the possible amounts available to Ms. Osborne would have been $160,000 total available coverage. Geico then applied a $30,000 credit from Mr. Ashworth's, from the payment under Mr. Ashworth's policy. Now Geico sees that it has available to pay to Mrs. Osborne $130,000. On April 6th of 2020, 3 checks were sent to Ms. Osborne, one in the amount of $100,000, one in the amount of $15,000, and another in the amount of $15,000. So 3 checks totaling $130,000 were sent to Ms. Osborne's counsel. And then if you add back in the $30,000 credit, that would get you to $160,000.
Okay.
So Geico is only contending that they were allowed a credit of $30,000.
And so just to make sure I understand this, you're saying, you know, she had $160,000 in available coverage from these 3 policies.
Yes, ma'am.
Mr. Ashworth's policy paid out its limits of $30,000. If her coverage is for underinsured means that person doesn't have enough money, doesn't have enough insurance to cover your loss. Just from a policy or just logical standpoint, if she's owed $160,000 in uninsured, underinsured combined coverage, why does the $30,000 that the guy did have even count as a credit? In other words, if you're insuring somebody for underinsured, don't you contemplate that there might be something that they're paid that's just under the amount it should be?
I think I understand the question.
Hey.
Let me try to answer it, and if I
Okay.
don't, please
No,
let me
no.
know. So first of all, I think one thing that's important to note is if we had only been dealing with an underinsured vehicle in this case, then the available coverage would have been less, because what we've called those 2 smaller policies only provided uninsured coverage. So if we had only had an
Let me just make sure
Sure.
I understand. The 2 smaller policies don't have UIM at all.
correct.
Okay, so
So
then,
in that case, if we had only had an underinsured vehicle, there would have been a $100,000 limit available under policy 65. A $30,000 credit would have been applied based on Mr. Ashworth's, the payment under his policy. There would have then been $70,000 of available coverage. If all of that was tendered, Ms. Osborne would have received $100,000. So there would have actually been less in that situation. If, in this case, because Geico looked at this with an eye toward the uninsured coverage, there was actually more coverage available to Ms. Osborne. I'm concerned that I might have confused you. Would you like for me to
I'm sure it's not your fault. I'm sure it's not your fault. I'm just trying to understand. The smaller policies didn't even include UIM coverage.
That is correct. So if this had been a case involving only an underinsured vehicle, those 2 policies wouldn't even be before us.
But they are, because this did
Right.
include
Yes.
an uninsured vehicle.
But I was thinking the first part of your question was about if we had only been dealing with an underinsured vehicle, then that would have put us in a completely different scenario for the amount of coverage available. But I'm sorry if I misunderstood the question.
And we've asked you a lot of questions. and it looks like you're close to your time.
Yes,
I'm going
ma'am.
to give you an extra minute because
well-
we've taken so much of your time.
Thank you very much. I appreciate it, and I appreciate the questions as well. If I could just briefly address the claims that the Mrs. Osborne included based on bad faith and unfair and deceptive trade practices. We contend that the trial court properly dismissed those claims as well. First of all, in the event that the declaratory judgment decision by the trial court is affirmed, those claims would not be an issue. But just to address those briefly, the allegation has been made about bad faith. And our courts, this court has held before that bad faith is not an honest disagreement on a coverage question or on it's not, bad faith doesn't arise when there's an honest disagreement over coverage. That's been held numerous times in cases by this court. The cases that look at bad faith also often look very closely at the timeline of the way that the case unfolded. And I do think that's important to note in this case. We had a very short, very compact timeline where the first claims by Ms. Osborne to Geico were made in early March of 2020, which was about a month before the statute of limitations ran. Geico maintained over the next 30 days or so, maintained very constant contact with plaintiff's counsel, advising that they had some questions, that they were going to refer it to counsel for a coverage opinion. At one point, plaintiff, Ms. Osborne's counsel requested a response to the demand and gave a deadline, however, proceeded with filing suit only 4 days later before that deadline was even reached. But within 1 month of the demand, Geico had referred the case to counsel, a coverage opinion had been done, and checks were issued. That certainly does not rise to any level of bad faith that has been examined in other cases by this court, where even gaps approaching a year were not unreasonable under certain circumstances. But in any event, in our case, we believe that there is no claim for bad faith because it was an honest disagreement, an honest exchange of information about the coverage issues, and within 1 month, checks were issued. In conclusion, Your Honors, we would ask that this court affirm the ruling of the trial court that granted summary judgment in favor of Geico.
Thank you, Ms.
Thank you.
May it please the court. My friend, in her brief and in the argument today, did not address the language in B4, at the beginning of B4, that is clear and says, shall, in addition to, provide UIM, and that UIM and UM shall be in equal amounts. My friend relies on, pointed to paragraph in SA, paragraph that says that the statute shall not be interpreted to require UM or UIM in amounts not purchased. But that provision cannot be read to overrule or override the introduction in the first paragraph of B4, which requires that UM and UIM shall be in addition to each other and shall be in equal amounts. And to the extent that the combined limits language says they're not in addition to each other and they're not in additional amounts, it violates the statute, and the statute has to control.
So your argument is that the statute compels an interpretation of, I'm going back to pages 58 and 59 in the record, you're contending that the statute compels, when we look at C, combined uninsured / underinsured coverage, each person $100,000, each occurrence $300,000, You're saying that the statute compels us to construe that to mean $200,000.
I'm saying that it compels it to read $100,000 of UM and $100,000 of UIM. And the language in the statute is up here on your screen. The limits shall be in equal amounts. It shall be equal to the amounts of uninsured, and it shall be in addition to the coverage in subsection 3, which is uninsured coverage. That is clear language, it's unequivocal language, and it's not ambiguous. At most, subparagraph N of the statute could create an ambiguity with before. But as the court reminded us in Lunsford this summer, if there's an ambiguity in the statute, it must be resolved in a manner that enables the insured victim to access UIM in the greatest number of circumstances.
Okay. And I know your time is short. I just want to, I'm taking this from Ms. Rao's brief as opposed to her oral argument. If this panel were to rule in your client's favor on this issue, insurance companies, you know, all across North Carolina and many policies would find themselves having exposure of twice what Ms. Rao argues they should have. Is that right?
Possibly.
Okay.
In those circumstances when when there's multiple tortfeasors, one uninsured, one underinsured.
So only when there's
But the
multiple
statute is what
tortfeasors,
requires-
and only when there's multiple tortfeasors, and only when one's uninsured and one's underinsured. Because if you had multiple tortfeasors and they were both uninsured, you would agree it's just $100,000. Is that right?
There's a debate under the language of the UIM section, but that's not what we have here. If the uninsured vehicle had $100,000 in coverage, we wouldn't be talking about UM at all. But what we
Right.
have is an uninsured motorist and an underinsured motorist, and a statute that's written into the policy that says that the statute shall provide UIM in addition to UM, and that they shall be in equal amounts. And that language is clear. The Mabe case, the insurer in the Mabe case that's cited in the briefs, also had an argument that we didn't charge enough of a premium. And that argument did not hold sway. The language of the statute that did not envision a family exclusion is what held its sway before the court, because the language of the statute controls. It has to, because that's what the General Assembly has declared. Judge Arrowwood, you asked about the double dipping. And the double dipping, I want to be clear, comes in, and I don't want to sound or be presumptuous, but the double dipping comes in if this court reverses on the UIM question, because under the UIM statute, before, they do get a credit for the amount of Mr. Ashworth's liability tender. And they can't have it in the UIM setting and in the UM setting. And the language that was addressed, actually, the Lunsford court, I guess I need to conclude.
Well, I'll ask you one more, and it's partly my inquisitiveness that's making this take a little longer. You've already made the argument that the statute for UM doesn't provide for this credit, that the statute for UIM, okay? If GEICO had applied this credit to the combined UIM in policy 65 and not to the smaller policies, as I'll refer to them, then it would be under a statute that allows for that credit.
Not on uninsured coverage.
But for UIM.
That's correct. If it had paid the UIM, it would have gotten and it still is entitled to the credit when it does pay its UIM if this court reverses. And I see that I've got 15 seconds left.
Yes.
What we are asking this court to do is to reverse the grant of summary judgment to GEICO and either enter summary judgment itself or instruct the trial court on remand to enter summary judgment against the movement, because the coverage questions are clear. There is UIM, there shall be UIM in addition to UM coverage, and they shall be in equal amounts. and there is no language in the statute that authorizes the coverage to be reduced by the amount paid by another tortfeasor. We also ask the court to remand the unfair and deceptive trade practices claims, and I will rely on my brief for why.
Thank you very much.
Thank you, Your Honors.
Thank you, counsel. The case is submitted.